The fallout continues in the Manhattan District Attorney criminal case against Donald Trump. We learned earlier in the week that there was 31,000 documents turned over by the Department of Justice, quite literally at the 11th hour before trial was scheduled on March 25th, 2024. The District Attorney, Alvin Bragg, provided notice to the court about this situation. Of course, that invited Donald Trump's lawyer, Todd Blanche, to put forward his own position here. A letter was submitted earlier in the day, and Trump's lawyers are saying that as a result of this 31,000 documents, they want to now hold a hearing on the date that trial is scheduled for on March 25th. Trump's lawyers then say that even though Alvin Bragg's requesting a 30-day delay, that coincides with the Passover holiday. So Trump's lawyers say, well, it can't go then. And then Trump's lawyers say they want additional time now to try to determine if there was misconduct by the Department of Justice in not turning over these records, if there was misconduct by the district attorney's office in not making the correct type of request to the Department of Justice. You see in this letter, Todd Blanche, Trump's lawyer, trying to pit the Manhattan District Attorney's Office against the SDNY, federal prosecutors, and try to make them kind of point fingers at each other. There's a lot now for Judge Juan Merchan to consider. There was also a response by Manhattan District Attorney Alvin Bragg as well, saying that they now have noticed that there's only 15,000 more records that are going to be turned over today, although I note that previously he used the word pages. Now he uses the word records right here. I mean, Popok, I think you and I both believe, regardless of who the criminal defendant is, a criminal defendant, I don't care if it's Trump or whoever, is entitled to have the discovery and review it before a criminal trial. Now, what that should mean for whether it's a 90-day delay or more or a 30-day delay, I think it should be closer to a 30-day delay. But there's a lot of chaos happening right now at the 11th hour that nobody expected. What do you make of today's letters? Where are we right now?
Yeah, I think it's a little bit of an unforced error by the Manhattan DA's office. We love the Manhattan DA's office, but we have to call it for what it is here on the Legal AF breakout hot take like this. What we're talking about are documents that the Southern District of New York prosecutors, who are the arm of the Department of Justice, had on sort of related matters involving Michael Cohen, our fellow podcaster here, involving Alan Weisselberg, involving some investigations that the Department of Justice through the Southern District of New York, which is one of their elite divisions of the U.S. Attorney's Office, conducted before the Manhattan DA started its investigation that ultimately led to the indictment of Donald Trump. I would have thought, frankly, and I know there's often turf warfare between the Manhattan DA, who, for those that are abroad and follow us or don't follow our legal systems as closely as you and I do, we have a state prosecutor in the Manhattan DA, and we have the federal prosecutors, and they sometimes overlap, and sometimes there's turf wars between them. The Department of Justice at the time was under Donald Trump, primarily Bill Barr. You know, to use a vernacular of Donald Trump, it was the Trump Department of Justice. But they did take interviews and do investigations. There were some documents. Now, there was never an overlapping prosecution, so it wasn't a matter of turf war in the sense that the Manhattan DA had to defer and bow out and let the prosecutors go first on the feds, although there was a little bit of that in the beginning. But I would have thought, frankly, at the time they brought the indictment or soon thereafter, they would have had the entire package of whatever the Southern District of New York Attorney General's, U.S. Attorney's Office was going to turn over. They would have already had that, sifted through it, sorted through it, and had it available to produce, if they needed to Donald Trump as part of defense material that it was appropriate to his defense. Failing that, that's on Manhattan DA. On Trump is the fact that he purposely waited until January to subpoena the U.S. Attorney's Office in the Southern District of New York. And we're only here in March, and that's not a lot of time. Now, why the documents, and it's a little bit higher number that I've read 75,000 plus 15,000, which is 90,000, which sounds like an extraordinary number, except for the people that practice law like you and me, Ben and Karen, It's not that big of a number. And you can sort through on a digital platform, on an e-discovery platform, you can sort through that in half a week and figure out which of that. I mean, the Manhattan DA isn't saying all of it is relevant to this case or, to the defense, but we're going to give it to you. We're going to dump it on you. They could sift through that relatively quickly. This doesn't take that amount sounds large, but I've heard much larger. It was like a terabyte of information. I mean, that's a lot of information. So partially it's the Manhattan DA's fault. Partially it's Trump's purposeful attempt to delay things by only issuing a subpoena in January. As to the 30 days versus 60 days versus 90 days, because Alvin Bragg is getting around to filing his motion for the exact extension that he wants. We've heard 30, I've heard up to 90. In any event, this is clear. The March 25th trial that you and I have been focused on with Karen is not happening. When both sides get up and say that they have a reason to delay, it ain't happening. But what I also don't think is happening is that Judge Merchan is going to wait another 10 days to conduct the hearing on March the 25th. In a little needling by the Trump side, like, well, we're not doing anything now that trial day. Let's do it on the trial day. Well, why don't we do it Monday? Why don't we do it Tuesday and have a discussion about it? Because there's other considerations here. The court is trying a large case with the Manhattan DA's office against a guy people might have heard of, Steve Bannon, and that's supposed to happen in April. So just moving the case ahead a month. Now, he could always kick the Bannon case and move the Bannon case, but that has implications. Now we're getting one step closer to the April 25th Supreme Court hearing and ultimate ruling in May or June about the D.C. election interference case, right? And so, I mean, all of this stuff, like it's going to be Passover. Suddenly the friend of the Jewish people, Donald Trump, worried about the observant Jews who couldn't be on the jury. I mean, it's just ridiculous stuff. Here's what I think happens, Ben. I want to hear your opinion. Judge Merchan holds a hearing early next week. He takes the Manhattan DA at his word that there should be additional time, but not all the way 90 days. I think he tries to fit it in April, May at worst. We don't care about Mar-a-Lago. That ain't happening in May. Judge Cannon has said she's not doing it in May. So the only consideration then for the Judge Merchan is giving them enough time. Frankly, I've been in defense cases in criminal matters where I got a dump from the prosecutors the night before that rivaled the size of this one, and I had no excuse but then to continue with the trial. So I don't think this will lead Merchan to issue an order of a major delay in the case. What do you think?
I think trial starts, if I'm being specific on my prediction, might as well try to hit the bullseye the week of May 6th. I think that you credit that week of Passover, people show up the following week, you do pretrial motions. I think you start your trial May 6th. By the way, that will be after the Supreme Court hears the immunity argument, the ridiculous immunity argument in the Washington, D.C. federal criminal case, which we'll have live here on the MeidasTouch network. And, I think Trump really strains his credibility, Popok, which, I mean, I guess I can say just by getting up in the morning. But specifically on this letter, when you have like Todd Blanche, Trump's lawyer, talk about the fact that you have this Judge Aileen Cannon trial scheduled for May 20th of 2024, when in fact there was a hearing where even when special counsel Jack Smith told Judge Cannon that he thought that case should go in July, Trump argued it should go never, and Judge Cannon seemed to side with the never over the July and said, yeah, this ain't happening in July. And then Judge Merchan knows those facts. And then when Trump doesn't acknowledge that, I think you're better off from a legal strategy to basically just say, look, we don't think there's going to be any other cases, but we need 90 days because we have to go through this, and that's just going to be the time, versus make it so patently obvious that you're just after delay. I think you lose credibility. So that's my prediction. May 6th, that week is when it starts. I'll give you the final word.
Sorry, folks. I think that's as reasonable as any. I think they need 30 days sounds reasonable to me. I'm fine with getting past any type of people that are observant and for the holidays, even if that just happens to land there. Although the joke in New York where I practice is, frankly, there's a holiday for one religion or another about every day. I used to park a car on the street, and alternate street of the street side of the street parking is suspended during holidays, and there used to be a lot of them. So judges don't usually, yes, they want to be accommodating, but they don't usually, religious holiday is not enough to delay a trial. But I like where your head's at, and I think it gets the trial up and running and completed by June, and it gives time if Judge Chutkan gets the case returned to her, which we all expect and hope from a Supreme Court after hearing oral argument at the end of April, before they end their term in June. She says, I'm going to add 90 days, 89 days. That's where the case was frozen at the time of the immunity. Giving him 89 days puts her into July or August, which gives her enough time to try her case. So we went from, on Legal AF, being sort of down in the dumps about there may not be any trial going on before November 5th, to now with the Georgia case with its wheels back on, led by the conductor Fawny Willis. No, I don't think that trial is going to be before November, but at least it's back on. Manhattan, maybe a month delay, and a trial of a DC election interference case. Things are looking up.
Absolutely. Everyone, make sure you subscribe to the Legal AF podcast wherever audio podcasts are available. Take you 10 seconds to do it. Just search Legal AF, hit subscribe. And of course, subscribe to our YouTube channel right here. Let's get to 3 million subscribers together and have a wonderful day.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.